My name is Dan Hohenstein. This is EDU 503 Sports Law, and I chose to cover Behrman versus the University of Notre Dame for my case study presentation. This specific incident happened on October 27, 1979, when Mr. and Mrs. Behrman attended a football game at the University of Notre Dame. Here we have the plaintiff, Christina Behrman. She suffered a broken leg when she was knocked down by a drunk individual as she was returning to her car after a Notre Dame football game. The defendant, the University of Notre Dame, before liability may be imposed on the inviter, it must have actual or constructive knowledge of the danger. This case was taken to the Indiana's District of Appeals 3rd District in 1983. Let's take a look at a few more of the facts of this case. As the Behrmans were leaving the game shortly before it ended, they saw two men fighting in the parking lot, who both appeared to be intoxicated. After the fight stopped, one of the men walked past the Behrmans and a few minutes later fell into the back of Mrs. Behrman, knocking her down to the ground and causing her to break her leg. In the parking lot, there were no ushers or security personnel in the area when the incident occurred. As a result of this incident, the Behrmans sued the University of Notre Dame for damages resulting from her injuries. After the close of all evidence, the trial court granted Notre Dame's motion for judgment on the evidence. So let's take a look at both sides of this argument. Christina Behrman's argument is, as a business invitee, Notre Dame owed to her a duty to protect her from injury caused by the acts of other persons on the premises. The University of Notre Dame's argument is that absent notice or knowledge of any particular danger to a patron, the university cannot be held liable for the acts of the third persons. It appears both sides have a good argument, but let's take a look at the law that applies to this case. The possessor of land who holds it open to the public must know that unsafe acts are occurring or likely to occur, or they must give a warning adequate to enable the visitors to avoid harm or otherwise to protect themselves against it. The possessor of land only has the duty to police premises if they know of danger or from past experiences. There is a likelihood of conduct that endangers the safety of the public. If the place or character of his business, in this case Notre Dame, or his past experience is such that he should reasonably anticipate careless or criminal conduct on the part of third persons, he may under a duty to take precautions against it, and to provide reasonably sufficient numbers of servants to afford a reasonable protection. So what does all this mean, and what did the court find? They found that the University of Notre Dame is aware that alcoholic beverages are consumed on the premises before and during the football games. They're also aware that tailgate parties are held in the parking lot areas around the stadium. Even though there was no showing that the university had reason to know of the particular danger posed by the drunk who injured Mrs. Behrman, it had reason to know that some people would become intoxicated and pose a general threat to the safety of other patrons. Notre Dame is also under a duty to take responsible precautions to protect those who attend its football games from injury caused by the acts of third persons. The question is whether the protective measures employed by Notre Dame were inadequate, and, if so, whether such inadequacy contributed to Mrs. Behrman's injuries are questions for the jury. Therefore, we reverse the judgment of the trial court and remand this case for proceedings consistent with the opinion. So what does this mean for the AD? The AD has a duty to plan, they have a duty to supervise, a duty to warn, duty to disclose and inform, a duty to develop an emergency response plan. I would have to look more into this, and my guess is something like this has happened since, but they have a duty to plan. My guess is that they know where most tailgates and where most people are drinking before the game. With that being said, you need to plan ahead of time and make sure that there is supervision in these areas, especially since you are aware that people may be getting intoxicated. One way to avoid another situation like this would be to have a specific parking lot for invitees like this that may not be taking in alcohol consumption. I would recommend having a parking lot like this pretty close to the stadium so that people are not having to walk through other parking areas like Mrs. Behrman had to. Seeing this specific case and hearing Mrs. Behrman's case, an AD has the duty to develop an emergency response plan in case something like this were to happen. But like spoken before, they would need to be notified and aware of certain situations if something were to happen like this. Thank you for watching my case study presentation.